Welcome to another webinar of WIFPR. Today we're very happy to host Tony Casey from the University of Chicago, who is going to talk about good faith filing in Chapter 11. I have also David Skeel here with me from the law school at the University of Pennsylvania, and both he and I will moderate the discussion. We're going to start with Tony presenting for 10 to 15 minutes, and then we will have questions from David and I, and also from the audience. Before I let Tony begin the presentation, let me just say a few words. WIFPR is the Wharton Initiative on Financial Policy and Regulation, and I am Itay Goldstein, the director of WIFPR. One of the things that we do here at WIFPR is to commission white papers on policy issues related to financial regulation at the intersection of finance and law. We commissioned this white paper from Tony. After we have a first draft of the paper, we convene a roundtable with experts in the area, from academia, from practice, from policy, and they give a lot of comments. We have a very lively debate. We had that a few months ago, and Tony went back and revised the paper, and now there is the final version of the white paper that is available on our website and that he will present. With no further ado, Tony, please go ahead and present, and we will then start the discussion.
Great. Thank you for having me. Thank you for this whole project. It's been a great experience. As noted, I presented the paper in very early draft form a few months ago. For those of you who saw that, and when you'll see this, there's quite a lot that changed because the feedback was extensive and super helpful. So I'll start sharing slides if I get going here. So hopefully that is visible. The paper is, and the proposal in the paper is about good faith filing in Chapter 11, is noted. And the question really for that is what the rule should be in bankruptcy, corporate bankruptcy, for when a debtor can file a Chapter 11 bankruptcy proceeding. The good faith filing rule, which I'll talk about in a few minutes, is really the way the courts have looked at the question in existing cases. So what I've suggested in this paper is we should have a different rule. We should replace what we talk about as good faith filing with something I call, but I'm not original here, this is based on courts have used this as part of a test, an objective futility rule. So you should be able to file a bankruptcy, Chapter 11 corporate bankruptcy, as long as the case is not objectively futile. And in the first, when I walk through the proposal, I have a first best, second best. In the first best world, that's the rule. In the second best world, we define good faith to make that the rule, which is not so different than some courts, but very different from other courts. So the question here is, a debtor files for bankruptcy, a corporate debtor, and someone challenges the filing. And they say, this case doesn't belong in Chapter 11 bankruptcy. It should be resolved through non-bankruptcy law, so you should dismiss the case. And the question is when a court should grant that motion and dismiss it, and when it should let the case go forward. The place to start, this is a legal question with anything, is the statute. And so these motions are brought to the court. So debtor files for bankruptcy, and an objector, usually a creditor, says, this should be dismissed, and they use the phrase for cause, because that's what the statute says. So the statute is 11 USC 1112, and it says that you can dismiss a case. You can also convert it to Chapter 7 and liquidate, but otherwise you can dismiss a case, quote, for cause. The statute then has a list of 16 things that would allow a court to dismiss a case for cause. Everyone agrees that this is a list of examples. It's not exhaustive, because the list starts with cause includes the following things. It doesn't say cause is, it just says includes. And on this slide, you'll see there's examples. So if you can't confirm a plan, the court can dismiss. If the debtor doesn't comply with a court order, the court can dismiss. If the debtor's not paying its taxes, if it's using cash that it's not allowed to use, if it has a plan that's been confirmed but it can't consummate, all of these are reasons to dismiss a case for cause. So there's 16 examples. Every major court to deal with this has found a 17th reason to dismiss, and that's for lack of good faith. So they've inferred that the code has a good faith requirement that a debtor must have filed bankruptcy in good faith. Now, that the courts agree on. What they don't agree on is, what does good faith mean? Some courts say, well, we're going to do a case-specific inquiry and look at the totality of circumstances. For example, that's what Fifth Circuit bankruptcy courts, the Fifth Circuit and the courts in the Fifth Circuit do. Other courts have said that in order for the challenger to get the case dismissed, they have to show both that the case is objectively futile. I'll talk about the definition of that in a minute, because that's the test I want to propose should be the ultimate uniform test for this, and was filed subjectively in bad faith. So you're looking at the objective futility of the case and the bad faith of the debtor. The Fourth Circuit and the Second Circuit have adopted that approach, which is generally viewed as the most debtor-friendly approach, allowing a case to go forward if it's not objectively futile or wasn't filed in bad faith. The Third Circuit recently, and this is why this has become a kind of hot topic in the last 2 years, the Third Circuit in the LTL, which is also known as the Johnson & Johnson talc bankruptcy, said the debtor needs to show immediate financial distress. So it needs to show not that it's insolvent, but there is financial distress looming at some level of immediacy that justifies the filing. They don't tell us what immediate means, which is what some have wondered, if this outcome will lead to lots and lots of litigation. But they said in that case, there wasn't immediate financial distress. So that was the LTL was a subsidiary of Johnson & Johnson that filed for bankruptcy. That got dismissed under that opinion. They then refiled again in the Third Circuit, got dismissed a second time, still wasn't immediate financial distress. And just in the last week, they filed in the Fifth Circuit a round 3. Now in the Fifth Circuit, they'll likely be subject to a different test, this totality of circumstances. The 2 cases in the paper I used I used 3 cases, but the 2 really exemplary cases to understand what's at stake here are that LTL case that I just mentioned and National Rifle Association. The reason I think these are exemplary cases is one is the easy case and one is the hard case. National Rifle Association is the easy case. So this case filed a few years back in Texas, and the National Rifle Association, through a subsidiary, filed for bankruptcy in the Northern District of Texas, and basically said, we are filing because the New York Attorney General is trying to regulate us, accusing us of fraud, trying to shut down this nonprofit that exists under New York law. And we want to get basically out of the regulation of the New York Attorney General. It was a striking case because both the filings, but especially the testimony of the head of the NRA at the hearing were clear that we have no financial problems. We're not doing this because of multiple litigation problems. We're not doing this because of collective action. We are doing this to get around the New York Attorney General. We want to move our New York nonprofit to Texas. That case was dismissed as being filed in bad faith, and the court said it lacks a bankruptcy purpose. There's nothing bankruptcy law can do to help you not be regulated as a New York nonprofit by the New York Attorney General. And the analogy you can think, if you're an illegal entity, if you're a drug cartel and the government's trying to shut you down, bankruptcy doesn't let you stop that. And here the New York Attorney General, whether they're right or wrong or will win, they had brought cases saying this was a fraudulent enterprise and trying to regulate it that way. The bankruptcy court said that's not a case that belongs in bankruptcy. Absolutely right. LTL management is a much more controversial case. So here, Johnson & Johnson has a subsidiary facing tens of thousands of mass tort claims. They structure what's known as a Texas two-step that separates the liabilities and the assets. Now, the reason they do that is they want to simplify what the bankruptcy that's about to happen. So the two-step is you separate liabilities and assets. That's step one. Step two, you file the liability entity into bankruptcy. The reason for the separation is to not interfere with the operations of your other businesses. So with J&J, Band-Aid, Baby Shampoo, Neutrogena, they just wanted to deal with liabilities related to and it was baby powder was the product. Now, in order to make sure that that separation wasn't a fraudulent transfer, they included a funding agreement that said all of the value of the assets is still available when liability is determined. And we guarantee it with those assets and a parent guarantee from Johnson & Johnson. The Third Circuit dismissed that case, not because of the separation, not because of the structure, but simply because with that funding agreement, the debtor, they said, wasn't in immediate financial distress because more money was available for those claimants than was likely to ever be needed. And so they said, you're not in immediate financial distress. There's some possibilities in the future that you might not be able to pay, but that's not immediate. And so the irony was that it was bad faith because the debtor had made too much money available for its creditors. And that was the dismissal that the Third Circuit ordered. And it really, the worry, I think, from bankruptcy practitioners is the way it was stated was very general and nothing to do with anything in that case other than the amount of money available, which suggested that we have a new rule that you need to be really close to insolvency or some closeness to insolvency. So this got people thinking about what the rule should be. And there's actually a proposal before Congress to make it even easier to dismiss a case like J&J, like LTL, adding a bad faith to the list of 16 things in 1112. So with that background, I started thinking about what should the optimal initiation rule in bankruptcy be. And so the proposal in the paper is that is a new optimal rule. And when designing an optimal rule, there are a few things you need to think about and get right. The initiation rule in bankruptcy and corporate insolvency we're talking about can be, you can have different systems. And around the world, we have all kinds of different insolvency systems. The initiation rule should work with the other rules to get the optimal number of filings and the optimal timing of filing. So you don't want cases that don't belong in insolvency going into insolvency. You don't want cases that do belong not going in. And you want them to go in not too late, not too early, at the right time. You're never going to get that perfect. So you've got to balance the optimal timing and optimal number. And one thing to take into account is the different costs of false positives and false negatives. And one thing I point out in this project, and I'm kind of exploring this in other things, is the false positive cost is much lower than the false negative cost. So if a company files for bankruptcy that shouldn't be there, ultimately that'll slow things down, and ultimately that case will end up outside of bankruptcy. That's a litigation cost, that's a delay cost. If a company that should be in bankruptcy doesn't end up in bankruptcy, it'll, in Chapter 11 reorganization, it'll likely fail and liquidate and be gone before we can resolve the false negative problem, right? So if you file too late, your business is lost. If you file too early, you've got a lot of kind of litigation tactics to deal with. And so the costs are different, losing a business versus having some litigation costs. And to support this, one thing to note is the US has always allowed early filing and been very liberal in filing, whereas other jurisdictions have not. And if you look around the world, they've started adopting what they call pre-insolvency proceedings to solve for the problem that you can't file for bankruptcy in Europe, for example, without being insolvent. And that means that you're too late. And so what did they do? They created pre-insolvency proceedings to let you do what in the US you can do by filing before you're in fully in financial distress. The rule should also minimize litigation costs. You don't want to spend the first 2 months of a bankruptcy case litigating whether you should be in a bankruptcy case. And so you want to make sure that you're not wasting resources and time over that question, especially if the rule is whether the person had the right mindset, things that are not objective and they're hard to determine. So you want to have easy to apply rules at the beginning of bankruptcy and things that if you litigate, it should be about objective tests. And then you should account for the other rules in bankruptcy. Who has control, who gets what, who gets to vote. And this is an old point. My colleague, Randy Picker, made this point in the 90s when he said in a paper that the debtor's right to file, the US gives the debtor the right to file for bankruptcy very liberally, and that gives the debtor power. But the reason why we do that is otherwise the debtor loses value. The debtor's the one who, in some sense, harmed the most by bankruptcy. Equity and management is putting themselves at the whim of the court for the benefit of the creditors. And so we want to give them the incentive to file. And so we compensate them for filing early by giving them this control and giving them this power. And again, if you look around the world, other jurisdictions have done the opposite and penalize people for filing too early. And, ultimately you don't get the right number of filing, you don't get the right timing, and they've been moving toward a US system. All right, so the rule should be, as I said, very easy to apply, very, because of the asymmetry in false positives, false negatives, should favor filing, not disfavor it. And so that's where I suggest it should just be the objective futility test. If the debtor can at filing explain why it filed for bankruptcy and say, here, I'm going to propose a plan, and that plan can be confirmed and preserve value for the estate, the filing is okay. Now, the NRA wouldn't meet that test because there's no confirmable plan that would have stopped the New York Attorney General from regulating NRA. That was a bad faith filing. It was objectively futile. But in Johnson & Johnson, they're going to try to get a settlement through. That's something that will save litigation costs, will save the race to the courthouse, the collective action problem among creditors. That gets you the possibility of a confirmable plan that will preserve value for the estate. And this rule will allow most cases to go forward, just not the egregious ones. There are 3 ways to get to this rule, and this is my first best, second best. So the first best is the courts just recognize there's no good faith filing requirement, get rid of it. And if you look at the code, it's not in that list in 1112. It is, there are other requirements about like insolvency for Chapter 9 municipal bankruptcies. So that tells us if they wanted a financial requirement, they could have put it in, but they didn't for Chapter 11. There's a good faith requirement for proposing a plan of confirmation, which is we wait till the end of the case to look and see whether or not this is in good faith, because then we have all the information. All of those factors suggest the code doesn't have a good faith filing requirement. We do the good faith at the back end, not wasting time when we don't have information at the front end. I don't think the courts are going to do that. So I have a second best outcome, which is they say there is a good faith filing requirement, but it is objective futility. This is really close to the Second and Fourth Circuit. They say we look for objective futility and subjective bad faith. I think subjective bad faith leads us down litigating things that are not easily identifiable and doesn't do much work. Objective futility really is the rule you should be looking at. And if you look in the list of things in the code, can you confirm a plan is one of the items that you can dismiss for cause on. And so this gets to that, right? So if you can't confirm a plan, it's objectively futile. If on day one you can't confirm a plan, it would be objectively futile. And that's the kind of thing we should look for if you're talking about good faith. The third alternative, I think the second one is the most likely. The third alternative would be a simple statutory amendment to say, you can dismiss for objective futility, and then make that list of 16 plus objective futility, not examples, but an exhaustive list. These are the reasons you can dismiss a case. There is no other good faith requirement. It's just, we ask whether or not, and if you look on the slide, I have that call out, no realistic possibility that a confirmable plan of reorganization can preserve value for the estate. If you don't have that possibility, it's objectively futile. If you do, the case goes forward. Now, you can imagine iterations where you say we only do this once at the beginning of the case and once at the end. An alternative rule, especially if courts were doing this, they would say at any point during the case, if it becomes clear that it's objectively futile, you can dismiss. I think it's better to do it at the beginning and at confirmation rather than inviting litigation the whole way. But any of those versions would be better than the current system, which has lack of clarity, and the Third Circuit rule, which is going to lead to a lot of litigation about how insolvent are you? How close are you to the final, how close are you to not being able to pay your debts? I have just 2 more slides and I'll hand over for questions. The benefits of the rule I'm proposing is most consistent with the language and structure of the code. Another structure point is if you look at the list of 16 things in 1112, they're all things that happen after filing. So it's a little odd for the implied 17th thing to be your subjective bad faith or your financial distress the moment before filing. Everything else in the list is after filing. And so objective futility talks about confirmability of a plan, which is also an after filing question. So these are more consistent with the statutory language. It's the least costly to administer. You simply ask, do you have a stated reason to file? Can the challenger negate the possibility of that stated reason? Or like an NRA, is the stated reason not one that bankruptcy addresses? Bankruptcy addresses the collective action problem among creditors, not regulatory authority of the New York Attorney General. If we want to worry about the egregious cases, the NRA is one of them. Other cases, if you have one creditor, there's no collective action problem. If you're purely stalling let's say the enforcement of a secured creditor's foreclosure right and you have no other creditors, those are all cases that would be dismissed under objective futility because a plan of reorganization couldn't change those. And so the debtor has to say, no, here's a collective action problem I'm trying to solve, which in the Johnson & Johnson case would be the tens of thousands of litigants going after the same pool of assets and the same, the race to the courthouse. All right, the minimal cost of this rule. So you might say, wait a second, what about debtor misbehavior? Well, there's 2 reasons not to worry about that. One is, for the last 20 years, what people have been writing about in bankruptcy is that the debtor doesn't have as much power as they thought they had. The banks have this power. They exercise influence over the debtor. And so real world leverage affects the debtor's ability to file inappropriately. And if we still think the debtor can misbehave and file too often or too soon, there are other lesser mechanisms within the court's power to address that. So they could lift the automatic stay, they could limit injunctions, they could lift exclusivity. All of these things allow you to control the debtors trying to take advantage of bankruptcy without kicking a case out where the case might actually save value for the estate. And the kind of big picture way to think about this is, as I said before, one of the keys to the US system is that it allows early filing. It allows you, to use a metaphor some people use, to call the fire department before your house is already burned down. You get to, the smoke alarms are going off. There's a problem. Let's go into bankruptcy and resolve that problem. Let's not wait until we know that we've destroyed the value before we use these tools that we have. And the Third Circuit rule of immediate financial distress, might get you to waiting till the house is halfway burned down. It might not, because we don't know what immediate means. And either it's going to get us to the bad place or the good place. But in the interim, we're going to litigate that over and over and over again till we figure out where that line is. And that's the kind of rule we don't want to have. We don't want to have every debtor who might not be insolvent has to litigate for a month over, or 6 months or a year over whether or not they're insolvent enough to file. And that's the kind of core behind the proposal that I put in the paper. As I said, that can be implemented by judges or by statutory amendment. So I hope that was quick enough, and I'm looking forward to your questions, David and Itay.
Thanks, Tony.
Thank you.
Itay, do you want to jump in, or should I just start?
You can go ahead.
I will start firing away then. Thanks, Tony. Very, very interesting paper, and very important and timely topic. So my first question is a two-part question, kind of, and that is, why not just get rid of the good faith requirement altogether, is the first part of it. And the second part of it is, in a sense, your statutory analysis seems to suggest you should just get rid of it. And your objective futility standard is subject to the same criticism that you make of the other standards, that the statute doesn't provide for it. So why not just get rid of good faith?
So two answers. One was, that was where I started, and everyone in the room back in April thought I was really bonkers, right? And they said, there's no way that's going to happen. So I'm all for getting rid of the good faith requirement. I was told no judge and no Congress will do that. All right. So but this gets to your second point. So I think objective futility is already in there. So on the list of cause is, you have to be able to, if you can't confirm a plan, the case can be dismissed. Now, you could read the code in various ways about when does that mean, when do we judge that? But if ultimately, if it becomes clear at the end of the day that a plan can't be confirmed, the court will and can, under the statute, dismiss a bankruptcy. Making that part of the good faith requirement just moves it up and makes it clear that you can do that at the beginning. Now, I think the standard of showing that you have no confirmable plan at the beginning is fairly high for the challenger, right? So if we're at plan confirmation and the court's like, the plan you proposed won't be confirmed, then it's easy to say, we're going to dismiss the case unless you can tell me you've got something else you're thinking about. Now, think in the NRA, as long as the debtor committed to what it did, which was the point of this, is to stop the New York Attorney General. At any point you ask that question, the answer is there's no confirmable plan that can do that. And so that was why when I got pushback on getting rid of the requirement, I was like, it doesn't change the statute very much to say, fine, there's a good faith requirement and it's objective futility, which again, the Second and Fourth Circuit have said. In a perfect world, I think you get rid of it, because the code structure suggests there is no requirement, right? There's a requirement of good faith when you propose a plan. They know how to put a good faith requirement in. The list of things in 1112 are all about things that are going on during the operation of the case. So that's my very first best outcome. But in a world where judges are saying, listen, every court has said there's a good faith requirement, we just wanted to define it, I think then you look at the structure of the code and you say, well, objective futility is the way to go. And it gets you the same practical outcome without changing the precedent that much, and is consistent with the structure. But I agree with you that my reasoning leads to let's just get rid of it.
And I apologize for the sucker punch. I'd forgotten that you started out with a no good faith stand. I was pretty proud of myself for thinking of that. I should have gone back to my notes from the earlier conference. I have a follow-up, and then it looks like Itay may have a question. I'm not sure, but when you talk about NRA, you keep talking in what sound to me a little bit like subjective terms. You keep talking about what they said when they went into the court and what they seem to be doing. Would it have been possible for NRA to keep its case in bankruptcy if the public statements had been a little bit different than they were?
So it wasn't just the public statements. It was the filings, and I think most importantly, it was the testimony at the hearing, right? So I do think the case would have been a much different case under the Fifth Circuit totality of circumstances test. I don't know how it comes out, but under my test, it probably comes out differently if they put to the court different evidence. And so remember, courts are bound to make decisions on what's in the record. And in the record was the testimony of, we have not just financial distress, we're in the best financial condition we've ever been in. We're not really worried about all the potential litigation. It hasn't even been filed yet, right? Unlike J&J, these aren't filed cases. It's, theoretical litigation, but they disclaimed all of that and said, we're trying to leave New York. We're trying to get around the Attorney General. And at that point, like, you got to take the evidence as it is. And if that's what the debtor tells you. If they had said, no, we're actually worried about not the Attorney General, but other litigation that could ultimately eat up our resources, right? Then you get into, like, the way I would do it is not subjective. The way I would do it is, like, is this, plausibly true, right? And so the difference, but there's a nuance between what's going on in LTL and this hypothetical. So LTL, everyone knows there were tens of thousands, now hundreds of thousands or not, potentially there's going to be hundreds of thousands with future claimants' claims. And you're in a world where the question is just like, how immediate are they, right? That's the subjective, but they exist. And no one can deny that there's a possibility if 90% of those claims are good claims, it's insolvency. In NRA, you would have been speculating about future cases. They're not filed. We don't know exactly what they're about. And there you might say, look, that evidence just doesn't hit our evidentiary burden. It not because, like, it's too far in the future, because we just don't know. But if they have evidence of cases that are going to be filed or are filed, comes out very different. But they said to the court, like, that's not why we're here. We're here to get out of New York regulation. The other cases that'll be very clear and objective, like the one creditor case. No matter what you say, a one creditor case is not going to have anything bankruptcy can solve, right? So those are the cases that get dismissed. There should be very few of them, but it's not subjective. It's the evidence before the court.
Right. Tony, I think you make a very clear and concise point in the paper. It's a very clear policy proposal, and I think this is exactly what we are looking for here. But one question to ask you is whether you are worried a little more about some of the broader implications that this might have. So if you think about, what's leading into bankruptcy, there is a whole process of negotiation between debtors and creditors, and what is this going to do to this process of negotiation? Or are we going to see a lot of bankruptcies as a result of that? I think maybe thinking about the next iteration and what will be some of the consequences would be useful here.
Yeah, so my view, if you'd asked me 4 years ago, and the way I taught the class to my students was, cases don't get dismissed for lack of good faith very often. And the few examples that we would teach were clear, I thought. And now we live in a world where LTL surprised me. In the Fourth Circuit now, there's litigation about the other Texas two-step cases, which I thought were clearly filed in good faith, and they've been going for a while, and that was the original ruling, but now there's a new argument going to the Fourth Circuit. So in that sense, I think the consequences, the changed world is the one where my proposal isn't adopted and the Third Circuit's new rule takes hold. And that, I think, is going to lead to lots and lots of litigation and perhaps later filings. If the rule I'm proposing gets enacted or not adopted by judges, we would go back to not that many cases get dismissed for lack of good faith. I don't think that leads to a lot of increased filings. On the margin in the Third Circuit, it'll lead to more filings than the current rule, but I think that's a good thing. The negotiations before filing, this is when I talked about the real world leverage, right? A debtor often files when, after a negotiation with a secured creditor who's accelerating the loan and then gives them a forbearance for a certain amount of time, they can't show that they're going to turn things around, and then they file. Right, that I think is a good outcome. We have a pre-filing negotiation. Nothing changes there, and there are ways that sophisticated lenders can exercise leverage to prevent or accelerate filing. Nothing about this proposal changes that. So I don't think it changes the status quo much, other than preventing the litigation that I think is coming if that Third Circuit rule takes off, or if all the courts adopt the totality of circumstances rule. That's just always going to invite litigation. I think the Second and Fourth Circuit rules are closest to my proposal, and we haven't seen kind of like a flood of filings in either of those jurisdictions relative to the other jurisdictions that have slightly different rules.
Okay.
Okay.
David?
Yeah. So kind of continuing with where you went with that answer. One question I was going to ask, which you kind of answered, I think, is how big of a problem is this? So I'll ask the question in a different way, and that is this really just about the Texas two-step? And there's some judges that think that the Texas two-step is kind of cheating, and they're manipulating good faith doctrine to incorporate that idea, or is it something broader? And if it's about the Texas two-step, are they mistaken about the Texas two-step? I know where you'll go with that one.
Yeah. So on the last part, I don't think the Texas two-step is bad. I mean, it could be. As I noted, you separate an entity into liabilities and assets. You do it to reduce the costs of the bankruptcy and to streamline, and to reduce the number of parties that are potentially interfering. And so it looks like a pre-pack. It looks like a UK scheme of arrangement. And then you add the funding agreement to make sure it's not a fraudulent transfer. Without the funding agreement, a Texas two-step would be problematic. But just the quick explanation for listeners is they separate liabilities and assets, and then they say the value of the assets before the separation is available for whatever the liabilities end up being. So there, I think the Texas two-step is a positive, not a negative. But let's assume I didn't think that. I could imagine a world where you said, the Third Circuit had said, the Texas two-step's a problem, we're dismissing that's lack of good faith. If they had done that, that would narrow this problem to a debate about the Texas two-step. But they didn't say that at all, right? So the Third Circuit opinion has nothing to do on its language with the Texas two-step. It just said there's too much money available. And the implication is, in J&J, had the entity not split and just filed, it would have still been dismissed because the assets would have been there. And that's the problem. I'm pro Texas two-step, different question in this paper, but if they had filed and been dismissed without the two-step, that's a much bigger problem, right? So if you read that case, you say, wow, anytime you're not in immediate financial distress, regardless of your structure, the lower court can dismiss it. Now, your question implies maybe the lower court won't. Maybe the bankruptcy courts are going to say, we're just going to limit this to the two-step. But if you take the Third Circuit opinion seriously, there's now a financial distress requirement. And that worries me. And then I'll just add that the legislation that's being proposed before the Senate, I don't think it'll go very far. It adds a bad faith dismissal. It's intended to get at the Texas two-step, but it actually goes way broader than that. And so there is this worry that if you take either that legislation seriously or the Third Circuit, the problem becomes broader. It hasn't happened. We don't have cases where I'm like, oh no, this is being dismissed when it shouldn't be, other than the two-step. But again, if you take the language seriously, it is a broader problem.
One of the things that you're clearly concerned about, both in the paper and in what you just said, is applying an insolvency test, that you have to show, to use the Third Circuit language, immediate financial distress. Is an insolvency test ever appropriate at the beginning of the case, or is your view just that we should get out of the insolvency business at the beginning of the case?
Yeah, and to be fair to the Third Circuit, they don't require insolvency; they require the threat of insolvency.
Exactly. Exactly.
And they have a line like it has to be relevant. But no, I am where the way you framed it is right. I think we should get out of that business. It's not the litigation you want to have on day one, right? You might have insolvency trials later on when it comes to fraudulent transfers, when it comes to adequate protection, when it comes to this, valuation priority. It's not what you want to do on day one. You want to take advantage of the fact that people might settle, that you'll get more information. We do want to get out of that business. It should be a world where bankruptcy is about, can I solve a collective action problem? Can I solve some coordination problem that'll benefit the estate? And if we get into the insolvency business, not only do we kind of muck things up at the beginning, but then you get into weird questions in cases like American Airlines and Hertz, when they ended up solvent at the end of the case. Do I need to go back and do something? Do I need to relook at that? Everyone was sure it was insolvent. Everyone was wrong. I mean, wrong in hindsight's 2020. Like, it's not necessarily true that they were always insolvent. They could have come and gone. But like, do we have to litigate that every time a company value goes up again? And in crypto cases with volatility as it is, it could be solvent one day and solvent the next day. Again, how do you define insolvency? I just don't think we want to be in that business of deciding whether the case goes forward based on that. Insolvency trials are difficult, and they usually come up in fraudulent transfer cases. But we should limit that as much as possible, because judicial valuation is a pretty difficult thing, and not something I want to condition day two of the case on a trial on day one.
I thought you were going to say encourage. We don't want
Same thing.
Judges doing that. Do you worry at all that this vision that you're articulating extends the bankruptcy clause beyond where it can go? That bankruptcy clause was really about insolvency, and maybe there's some play in that, but this is going too far.
So yeah, I talk about this a little in the paper. I mean, if you take the Supreme Court seriously on this point, I'm not worried at all, because the last time they talked about it, they said the bankruptcy clause is anything that involves the relation between the debtor and a creditor. And the case law at the court has been pretty consistent that they don't read the bankruptcy clause narrowly. It's not read in some sort of originalist way. I think that's the right approach. If I were an originalist, I would have arguments against what I'm talking about. But if I were an originalist, I would have arguments against a lot of things we're doing in bankruptcy, right? So if you go back to the founding and you say, what was bankruptcy then? It wasn't a pro-debtor anything. There was debtor's prison. Bankruptcy was a process specifically for creditors of merchants, right? And so if we want to limit bankruptcy to a process that benefits creditors of merchants, that's a very different world than the one we live in. I'm not in favor of that. And the court hasn't gone that direction. In any case, it's an unbroken line of, we read the bankruptcy clause super broadly. Those are the Supreme Court cases. So I'm confident on the precedent. Again, I think an originalist could say you've got it all wrong, but they would be tearing apart Chapter 9, most of Chapter 13, subchapter 5. Like, there'd be so much in the bankruptcy code that we would have to revisit, that like this problem would be very small in that world, I think.
In this game. I think we're about out of time, but I do have one more question I want to try to sneak in, and I don't know if Itay wants to sneak in another question as well. And the last question that I had is, Involuntary bankruptcy change your thinking at all? I mean, would you have a more robust good faith requirement for involuntary bankruptcies, or are you going to keep the same rule?
Yeah, that's a great question. We have my colleague, a Bigelow fellow at Chicago, Jared Meyer, has a great new paper on this question of involuntary bankruptcy. This goes back to something I said earlier about the design of the whole system and what Randy Picker said about the benefit you give to the debtor, the compensation. Our system is a debtor in possession system. The debtor gets control. The debtor gets certain powers once the bankruptcy is filed. Part of that is because we have an absolute priority rule that's going to wipe the debtor out. You do need to think about all of that when designing a system. So in other jurisdictions like India, they have a creditor in possession system. So totally a different way of thinking about it. I think our involuntary rules, which are very rarely invoked, are and should be pretty technical. It's like, can you hit this and this? Like if you just check the box agreements, check the box things. So I guess I come out kind of the same place is if you do what the code requires as an involuntary, it should move forward. It shouldn't be about your subjective mindset as much as just, do you have the required debt? Have you shown the inability to pay debts as they become due? It doesn't happen very often in the U.S. system. If we had a more robust involuntary practice, I worry more. But you just don't see it in our system. I think to the extent you don't have absolute priority and the extent you have other control mechanisms, you need to think about it more. But with our system, I'm okay with the way it is, which is I think kind of where I want voluntary to go. It's just like, did you meet the basic requirements?
Yeah.
Okay, I think we should stop here. Thank you again, Tony. Thank you, David. This was a great discussion and great paper. I'm sure it will generate a lot more discussion going forward.
Thanks for having me. This is so much fun.
Yes. Thank you very much, everyone.
Thanks, y'all. Thanks, Tony.